Lawyer pro tip. Before the current lawyer in a file decides to throw the former lawyer under the bus in written pleadings, the current lawyer should bear in mind that in the future he may be the past lawyer that the new current lawyer decides to throw under the bus in written pleadings. Obviously. Viva Frei, Montreal litigator turned YouTuber, and it is vlog time and time for an update in the Akilah obviously versus Carl Benjamin lawsuit. And I promise you, I am not going to make incessant obviously jokes during this video. Obviously, literally. If you are new to this channel or you're new to the Akilah obviously situation, just a brief rundown. Her full name is Akilah Hughes. She has a YouTube channel called Akilah Obviously. She was a Hillary Clinton supporter in the 2016 presidential elections. In the context of the 2016 presidential elections, and more specifically Hillary Clinton's loss of it to Donald Trump, Akilah obviously put out a video called "We Thought She Would Win." It was a 9-minute and 50-second video documenting how Akilah and others thought Hillary Clinton would win, and documenting the whirlwind of emotions they felt as they realized Hillary Clinton would not win the presidential election. Carl Benjamin, aka Sargon of Akkad, or Akkad, I don't exactly know how to pronounce that. Let's just figure it out right now. Hey Siri, pronounce Sargon of Akkad.
I found this on the web for pronounce Sargon of Akkad. Check it out.
Sargon of Akkad. Thank you, Siri. Sargon of Akkad is a British YouTuber. He's relatively controversial. You can Google him and read his Wikipedia page for what it's worth. In the wake of Akilah obviously publishing her video entitled "We Thought She Would Lose," Sargon of Akkad published a video entitled "Sierra Juliet Whiskey Levels of Awareness." Sargon of Akkad's video with that apparently derogatory title was a 1-minute and 50-second re-edit of Akilah Obviously's original video. No specific commentary in that video, just a sort of reduction re-edit of the video for commentary purposes. Akilah Obviously apparently filed a copyright notice with YouTube. She filed a DMCA takedown notice, that is a Digital Millennial Copyright Act takedown notice, on the basis that the use Sargon of Akkad made of her original video was copyright infringement. Given the DMCA takedown notice that Akilah Obviously filed, YouTube took down Sargon of Akkad's video. Sargon of Akkad, knowing the law and being thoroughly convinced that his use was fair use, he filed a DMCA takedown counter notice. If Akilah obviously still thought that the use in question was copyright infringement, she would then have to take the matter before the courts for adjudication on the matter. And that's what she did. In a pre-motion conference in the context of this lawsuit, the judge in question asked Akilah or her attorneys why this wasn't quintessential fair use. In that pre-motion conference, in response to the judge's question, Akilah Hughes' attorneys contended that while it might be some form of commentary, it did not rise to the level of fair use. And when faced with a motion to dismiss from Sargon of Akkad's attorneys, the judge in the file did not agree with Akilah Hughes' attorneys. The judge dismissed the lawsuit on a motion to dismiss on the rather interesting basis that editing can constitute commentary. The judge dismissed the lawsuit, and Sargon of Akkad subsequently came in with a motion to claim legal fees. Now, although I strongly suspect that the vast majority of you watching this video have already seen my video on the subject, I did a vlog breaking down Sargon of Akkad's motion to reclaim legal fees. I will link that video right here. Give it a watch if you haven't seen it. It's a good one, if I do say so myself. Sargon of Akkad, through counsel, made a very compelling case as to why Akilah Hughes should be required to pay his legal fees in the order of $40,000, legal fees and court costs included. And obviously, Akilah obviously does not want to pay those legal fees. I did not mean to do that one. Sorry, I actually just meant obviously. Literally. Which brings us to our current vlog, Akilah Hughes' Memorandum of Law in support of plaintiff's opposition to defendant's motion for attorney's fees and costs. That is fancy lawyer talk for why I don't want to pay. Plaintiff submits his Memorandum of Law in opposition of defendant's motion for attorney's fees and costs under 17 U.S.C. Section 505 and Federal Rules of Civil Procedure 54D. Summary of the case. Plaintiff is a popular internet personality and content creator who publishes video content on her YouTube channel, Akilah Obviously. On the night of 2016 presidential election, plaintiff captured footage from Hillary Clinton's presidential watch party. You know what? We've already done this. I'm not going to read through it. I'll screenshot so you can make sure that I did an accurate job. Let's get to the juicy part. Upon the guidance of plaintiff's former counsel, plaintiff commenced the present lawsuit on August 25th, 2017. Why allege this in the memorandum? It is a not-so-subtle, obvious way of attempting to blame the former counsel for the current situation. And it reminds me that I actually forgot to mention something relatively critical. Akilah Hughes' first counsel in the file withdrew from the file. And you don't need to have much experience with the legal process to know that when an attorney withdraws from a file, it is generally speaking not a good sign. We don't know why or under what context Akilah Hughes' first counsel withdrew from the file, we just know that they did. Akilah Hughes obviously found new attorneys who took carriage of the file and brought it to the current situation, and in this pleading seemed to be placing some some of the blame on the previous counsel in the file who did not carry the file to the current situation. And I've got to say, this is a life pro tip for both client and attorney. Anybody who thinks that this is a good strategy has not had the experience to know why it is not a good strategy. From the client's perspective, this is not going to earn you any sympathy in front of the judge. Oh, my lawyer told me to do it. While it's true that the attorney is the advisor to the client, generally speaking, and exceptions aside, it is the client and the client alone who bears the responsibility of their lawsuit. And generally speaking, abuse and incompetence aside, when the court gets the impression that the client is trying to blame the weakness of their lawsuit on their attorney, they don't like it very much. And from the attorney's perspective, the courts also don't like it. There's an expression in French, les absents ont toujours tort, which means that those who are absent are always wrong. But judges who typically have a lot of experience as lawyers know how dirty it looks when current counsel tries to throw former counsel under the bus when former counsel is not there to defend themselves. Attorneys may do this for any number of reasons, but very rarely is it strategically benefit to do so. And the lawyer has to appreciate and anticipate that while they are currently the current counsel in a file, as soon as the very next day they could easily become the former counsel in a file who the current counsel is now throwing under the bus. It is a gratuitous comment, it is a losing strategy, it's not going to garner any sympathy before the court, neither for the client nor for the attorney. It might just confirm with the court that the plaintiff, who is now the losing party, just refuses to take responsibility for her own actions. End of rant, back to the memorandum. Subsequent to an initial conference held on March 9, 2018, where plaintiff was represented by new counsel, plaintiff submitted an initial settlement offer to defendant. No counteroffer or attempts to resolve the matter were made by defendant. Oh hey, you look good, where are you going? Her settlement offer was for Sargon of Akkad to pay her $46,000 to settle the dispute. Now, in law, there are some settlement offers which everyone knows are not settlement offers, they are actually only declarations of war. And some might suspect that making a settlement offer that defendant pay you more than they would ever be ordered to pay you on final judgment is not a settlement offer, it is, in fact, a declaration of war. And when you declare war on somebody else, you can't then fault them for not coming back with a settlement counteroffer, and a court is going to see through this. Instead, defendant filed a motion to dismiss, which was granted. Yeah, because the amount you demanded in your settlement offer was actually more than what would have been the cost of the defense. As an attorney, I am not averse to any settlement discussions. I in fact encourage them, but they have to be good faith settlement discussions. Ridiculous demands, declarations of war under the guise of settlement discussions are not legitimate, sincere settlement discussions. And to expect somebody to come back with a settlement counteroffer to what was never a bona fide, genuine, sincere settlement offer in the first place is asking someone to negotiate with themselves, and it's not something I ever suggest anybody do. Defendant moved for an award of attorney's fees and costs. Plaintiff now submits its opposition to defendant's motion. Standard. Section 505 of the Copyright Act grants the court discretion to award a prevailing party in a copyright infringement action reasonable attorney's fees and costs. Attorney's fees and costs should not be awarded as a matter of course, but rather a court must make a more particularized case-by-case assessment. In making an attorney's fees determination, a number of non-exclusive factors should be considered. Of those factors, objective reasonableness is afforded substantial weight. However, the ultimate inquiry is whether such an award furthers the large objectives of the Copyright Act. Alright, and from my limited understanding, because I am by no means an expert in this, being a Quebec attorney, this is just the legal standard that applies to whether or not a court awards legal fees, and from what I understand, it's relatively accurate. And evidence to this is, having read Sargon of Akkad's motion to claim legal fees, it seems relatively apparent that both attorneys are in agreement on the jurisprudential standards. But let's get to the argument. Plaintiff's litigation conduct was reasonable and her motivations were in good faith. While an award of attorney's fees and costs adds to the reward for a victory, it also enhances the penalty for a defeat. In cases where a good faith claim has been brought and lost, an award of attorney's fees may repress the purpose of the Copyright Act. This is especially true in the application of doctrines that are not clear-cut but require a case-by-case analysis. In these instances, it is difficult for a party to confidently know whether they will win or lose. Plaintiff commenced this action for copyright infringement with a good faith belief that defendant's copyright and uploading of wholesale reproductions of plaintiff's original content and adding a title was insufficient to amount to fair use. Plaintiff's motivations were clear. She believed that the secondary work was an infringement and that fair use did not apply. It is also clear that any heat of the moment banter between plaintiff and defendant is irrelevant to her motivations for commencing this action and to the present motion before us.
I'm sorry, and why exactly?
The heat of the moment banter to which Akilah Hughes is now referring refers at least in part to certain tweets that she made on the subject of her lawsuit against Sargon of Akkad. In those tweets, she referred to him as all sorts of names and threatened to bankrupt him. So why would it be true that her heat of the moment banter, in which she called Sargon of Akkad all sorts of terrible names, threatened to bankrupt him, have his Patreon account shut down, why would that not make evidence of her good or bad faith in the conduct of the lawsuit? If I'm asking the question, I suspect the court is also going to be asking the question, and I suspect the court might consider it to be somewhat relevant to determine her motivations in the conduct of this file. She's the smarty pants who's about to lose a copyright lawsuit against Sargon for having mocked her. I'm gonna take hundreds of thousands of dollars USD. I have a Christmas present on the way for both of you. I imagine if he has a Patreon, it isn't long for this world. It'll likely go the way of Sargon's did after someone reported his hate content. This is not the best evidence of someone's good faith. Now, I know what a lot of you are thinking to yourselves, and if you're not thinking it, you should be, that the good faith belief in a lawsuit does not necessarily equate to the good faith conduct between the parties. And if I'm her attorneys, I am going to argue that while there was animosity between the two of them, that didn't really have any effect on her good faith belief in the substance and validity of the lawsuit itself. The argument is there to be made, and it obviously needs to be made, but I've got to tell you, this type of evidence really allows a judge to cast some doubt on the good faith belief argument. Justice is human because judges are human, and when judges are faced with arguments that someone had a good faith belief in the validity of their lawsuit while also faced with this type of evidence, well, it nonetheless will have an impact on the judge. But I don't even think that this is going to be Akilah Hugh's biggest problem, so let's get to it. Plaintiff litigated her claims reasonably. Prior to the filing of defendant's motion to dismiss, plaintiff sought to settle this matter by providing defendant with an initial settlement offer while remaining open to settlement discussions. Plaintiff made a reasonable attempt to resolve the litigation in its early stages. Defendant chose not to counteroffer or attempt to engage in any discussion whatsoever and instead filed a motion to dismiss 10 days after receipt of plaintiff's initial settlement offer. So here's another pro tip, take it for what it's worth. Telling a judge what to think is less persuasive than leading a judge to where you want them to get. Alleging a fact is one thing, telling a judge how they should perceive that fact is another. The fact that is being alleged here, Akilah Hughes made a settlement offer. Okay. Calling it a reasonable settlement offer is not going to convince a judge of its reasonableness. In fact, it might just do the exact opposite. A judge might look at that $46,000 settlement offer and say, in no way was that reasonable. Why are you calling it reasonable? Not only was it not reasonable, it was patently unreasonable and further evidences your bad faith in the conduct of this court file. The other thing, it seems that Akilah Hughes is forgetting which judge she is talking to. She is talking to the same judge who presided over the pre-motion conference and who said the things he said in that pre-motion conference. And just to highlight a few of the things the judge said in that pre-motion conference, let's go to the transcript. The court. This is a pre-motion conference on the defendant's contemplated motion to dismiss. I have letters from the parties and I have reviewed them and done my own research. The purpose of a pre-motion conference is that I require these because I think they're helpful. I don't do it to make it harder to make a motion or to create work for lawyers. I just think that it gives me the ability to provide some insights or impressions early before you've dedicated yourselves to 25 pages worth of briefing, and I think that can be valuable. I never tell a party they can't make a motion, but I do sometimes say what I think of a motion, or at least give you a preview of what my initial thinking is on the merits of a motion. The court. Okay, it seems that the complaint concedes or acknowledges that, I'm not really sure what that means, SJW levels of awareness, but it seems that the complaint takes that as a kind of snarky, critical comment. Is that fair, Mrs. Grant? This is really for Mrs. Grant because it's her complaint. Are you conceding that it's criticism? Mrs. Grant, I mean, it could mean anything, SJW levels of awareness. It's some type of comment, but I don't think it's sufficient to rise to the level of fair use. The court. Well, if it is criticism of Ms. Hughes, if it is mocking her with her own work and a title, she's the social justice warrior, I presume, in the view of Mr. Benjamin or Sargon of Akkad, and this is belittling her by reference to a portion of her work, that would seem to me to be kind of quintessential fair use, right? Further on, Akilah Hughes' attorney's response as follows. Ms. Grant, we don't believe that merely taking one comment on a video, which you have taken wholeheartedly and reposted, is sufficient to rise to the level of fair use. The court. So how much do you need? I'm just thinking about Jon Stewart. I went to college with Jon Stewart. We weren't chummy, but anyway, he was a master, really, but he'd show a clip and sometimes he wouldn't use any words at all. He would just go and make a face like he was horrified, shocked, or appalled, and then he might just move on completely, so not even words, and yet clearly, unmistakably criticizing the person on that clip, or in some cases, perhaps the person who made the clip. Further on still, the bit where it says the SJW designation in the title is an abbreviation for social justice warrior, a title routinely used by Benjamin in a demeaning context to belittle proponents of perceived liberal social policies and stances. It's not exactly clear to me what SJW levels of awareness means, but you seem to be conceding that it is demeaning, belittling, and mocking, right? Ms. Grant, that is the plaintiff's belief. The court. Okay, look, it seems to me that whether this case is decided in a motion to dismiss or on summary judgment, this is likely to be fair use. It seems to me that the kind of mocking and social commentary and belittling and demeaning discourse is what's allowed and celebrated, and people make a living doing it. And so it seems to me that this is likely to be a fair use. This is not code. The court is telling Akilah Hughes that it believes that it constitutes fair use. Notwithstanding the very clear indication which way the court is already leaning on this, Akilah Hughes comes out with a settlement offer to the effect that Sargon of Akkad should pay her $46,000 for copyright infringement. Given the evidence of what some might feel to be a patently unreasonable settlement offer, her discourse on Twitter, her heat-of-the-moment banter, a court might not be convinced that she litigated her claim reasonably. You could try to tell the court what they should think of the facts until you're blue in the face, but the fact remains they're going to look at the facts and the facts alone, not your qualification of those facts. Defendant has already been adequately compensated. Defendant raised money to fund the defense in this lawsuit via a GoFundMe campaign. Defendant raised £95,000. This is approximately $121,000 US. Defendant incurred attorney's fees and costs totaling $33,000 plus $5,000 USD for the present motion. After deducting defendant's attorney's fees and costs from his total GoFundMe earnings, defendant earned a surplus of approximately $83,000 US. Again, qualifying a fact as opposed to alleging a fact. The fact here seems to be that Sargon of Akkad raised money on GoFundMe. Calling it earnings doesn't make it earnings. It might be the safety net for additional legal fees in case Akilah obviously appeals. It might be the safety net for additional legal fees going forward in the file. Sargon of Akkad may have agreed to donate any surplus of legal funds raised to a charity. Calling it earnings doesn't make it earnings, it just makes you look silly for presuming what it is. It's also a pretty silly argument to say that, look, as a result of my frivolous lawsuit, which I now lost, he was able to raise more money on GoFundMe than it cost him in defense, so he actually came out the victor. The argument at its core is pretty much just as absurd as saying, if I push someone in a puddle and they find a diamond ring in that puddle, they can no longer hold me responsible for having pushed them in that puddle in the first place. It is a bad argument, and sometimes better than making a bad argument is not making the bad argument because you are using up your goodwill with the court. An award of attorney's fees would not increase the deterrent effect. There is no precise rule or formula for making money attorney's fees determinations, but instead equitable discretion should be exercised. And courts must view all of the circumstances of a case on their own terms in light of the Copyright Act's essential goals. An award of attorney's fees is justified in particular circumstances to advance considerations of compensation and deterrence. This is not one of those particular circumstances.
Why not?
Considerations of deterrence may support an award of attorney's fees to the prevailing party when none of the other relevant factors justify denying such an award. As evidenced above, the other relevant factors do not support an award of attorney's fees. The plaintiff's motivations were in good faith and she litigated the case reasonably. Pro tip number 3 of this vlog, and it works on social media as well, repeating a conclusion does not make that conclusion any more legitimate. The plaintiff's motivations were in good faith and she litigated the case reasonably is a conclusion that is to be drawn from the evidence. It is not evidence itself. Notwithstanding the above, the defendant's success and his GoFundMe earnings have furthered the purpose of the Copyright Act, and an award of attorney's fees and costs would not add to the existing deterrent effect. Well, that is a very nice opinion, but you know what they say about opinions? Plaintiff has faced widespread public criticism as a result of losing this lawsuit. Thus, an award of attorney's fees will only be additional and unjust punishment for a good faith attempt to enforce her rights. Unjust is a matter of opinion and not a statement of fact, and we yet again just repeat the conclusion that it was good faith, which is itself a conclusion to be derived from the facts and not a fact itself. And can we just appreciate the argument that is being made here that because she's being mocked for having lost the lawsuit that she should not be required to pay the legal fees of the prevailing party? Setting aside the mockery part, it's precisely when a party loses a lawsuit that the court may award legal fees to the prevailing party. And the fact that she is by her own admission getting mocked might have something to do with the frivolity of the lawsuit in the first place. It might have to do with her in the heat of the moment banter on Twitter. She might be getting mocked precisely because she was abusing the legal process from the get-go. Conclusion: plaintiff commenced this action in good faith and litigated her claims reasonably with attempts to resolve this lawsuit in its early stages. Further, defendant has already been adequately compensated and an additional award would add no further deterrent effect. As such, plaintiff respectfully requests that the court exercises equitable discretion in denying defendant's motion for an award of attorney's fees and costs. My non-milquetoast fence-sitting prediction is that Akilah Hughes is going to be ordered to pay, if not all of Sargon of Akkad's legal fees, the vast majority of them, and here's why. The court clearly and unequivocally warned Akilah Hughes from the very beginning that her lawsuit was weak, if not quintessential fair use. The court gave her fair warning as to how they were going to rule in this case, and then she proceeded by making a settlement offer that is not a settlement offer. Her behind-the-scenes conduct, which she wants to qualify as in the heat-of-the-moment banter, is not in the heat-of-the-moment banter. It is evidence of malicious intent. At the very least, it's evidence that can allow a court to question her good faith belief in the validity of her lawsuit. The arguments for why Sargon of Akkad should not be awarded legal fees because of his GoFundMe page holds no water at all. Unless someone has case law out there that is proof to the contrary, I don't think it matters how someone finances their legal fees. The fact alone remains that he incurred those legal fees as a result of the frivolous lawsuit brought by Akilah Hughes. And finally, as relates to the quantum that Sargon of Akkad is claiming, it's actually quite reasonable given what was done in the file, and I don't see a judge reducing it substantially. The judge effectively warned Akilah Hughes of the risk going forward. She chose to move forward, and now she's going to have to live with those consequences. That is my prediction, and if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below. If you want to get some merch, I don't actually know if I sell this particular shirt. I think this might have been a one-off, but there are merch links. There is a Patreon link. There's a Subscribe Star link. There is, what's the other one? PayPal links to support the channel if you so choose. At the very least, you can choose to support the channel by sharing my links on social media. I greatly appreciate it, and now you know your vlog. Peace out.